Tonight, we ask whether the tussle between the presidency and Parliament is over the approval of ministerial nominees following the dismissal of the injunction application against President Akufo-Addo's ministerial nominees filed by South legislator Roxanne Nelson Dafiamekpo. We know that at some point the case was stood down for the court to verify some facts of the case, particularly regarding whether the bailiff had served the parties, especially the plaintiff, Mr. Dafiamekpo, with a hearing notice. The Attorney General, who actually filed for an expedited hearing, actually criticized the conduct of the MP's lawyer, describing it as the highest form of disrespect to the highest court of the land and as an unprofessional conduct. Now, we'll be hearing from the lawyer of Mr. Dafiamekpo. We'll also be having an experienced member of Parliament who is on the committee in Parliament in charge of subsidiary legislation and also a former Deputy Attorney General. We surely should be able to get to the bottom of this matter and understand what's happening in this particular case. Ultimately, the case being thrown out, does it end the convocation about this one? Certainly, we should be able to go straight to the law offices of Addo and Addo and appreciate what's been happening with that team because they failed to show up in court today. Ni Kpakpo Samuado speaks or is a lawyer for the member of Parliament who was in court earlier today. This is supposed to be the member of Parliament, Roxanne Nelson Dafiamekpo. So first and foremost, Ni Kpakpo Samuado, I hope you are doing well this evening.
Doing very well. How are you?
I'm doing well too. I'm just not sure why you didn't show up in court when there was a case you had filed and followed up and was interested in prosecuting on behalf of your client.
I should quite tell you that there must have been a reason why I didn't care. The reason is simple. We were not served with a process that indicated to us the date that the court was supposed to be settled. Now, we need to clear that issue immediately. A bailiff called me, let me get the exact time, called at exactly 10:50 a.m. yesterday to indicate to me that there was a process from the Supreme Court to be served. I said, unfortunately, I wasn't in Accra, so we should serve the plaintiff personally. And so he requested for the number. I gave the number of the Honorable Roxanne to him. And that was the last I had. In fact, he acknowledged my message at 10:57 a.m. So today I was shocked when I heard that he had gone to the Supreme Court to say that he came to my office and my front desk said I had instructed that they should not collect any process in respect of this particular case, to quote him. And so luckily, he probably didn't know that there's a CCTV system in my office with a voice capacity or capability. So he was recorded. And everything he said, I've released the CCTV footage, was a blatant lie. Nobody ever told him what he actually said in court today. Indeed, what he captured in the audio says that he was asked who he was. He came and identified himself as a bailiff and that he had a process. He removes the process from his bag, puts it on my front desk table. Then he asked, in fact, the receptionist saw my name on it and said, I wasn't around, and that he should wait for me to come so that he would give it to me and for me to sign. He then informs them that he needs to clarify with his boss whether that will be the procedure. He said he was making the call, he stepped out and never came back. And then he goes to make such a report. And so when we file an official search, I haven't been served, Roxanne hasn't been served, and there's nobody on record to have received the third process.
No.
And like even though he was being recorded. So I have released the CCTV and the audio accompanying it for all of you to play and hear.
Now, let me understand this. This bailiff was under oath in the highest court of the land.
Exactly.
And he was quite clear in his mind that...
But be that as it may, the court said once he had left the process on our table, it constituted good service. So we've gone past that. We are not going to debate anybody over that. The court has made a decision. We respect it. So let me clarify. The court has not thrown out our case. The court has dismissed our injunction application. That's fine. And so we are waiting for the court to hear the substantive matter.
The only point of interest to many people here was that it was this injunction that prompted the Speaker of Ghana's Parliament to stand down all forms of decision or consideration on whether or not Akufo-Addo's ministers.
Our interest was not to prevent the government from nominating or approving this minister. What we said was that there were 8 people on that list, no, 5 people on that list, who were part of the composite list. In our opinion, those 5 people have been removed from office cannot be reappointed as ministers without going through the prior approval of Parliament. And so if there was an ongoing vetting process, they should be added. The court said no, let Parliament continue with its vetting process. We will hear your case, but we cannot stop Parliament from going ahead with its vetting process. That is the decision of the court. You have to respect it, and then you move on. So we've moved on to our next case, which is what? The mandamus application to compel the president to receive the bill, the LGBTI bill from Parliament. We have asked for an expedited hearing of that matter, and the court registry has granted us the 8th of April to go and deal with that particular matter. So we'll be in court on the 8th to deal with that particular case.
Now, I'm interested in this because it's very fascinating, except that the Learned Attorney General criticized your conduct, describing it as the highest form of disrespect to the Apex Court and professional misconduct. The Attorney General
was not aware that the bailiff was lying. I have subsequently sent him copies of the CCTV footage. And clearly, I'm sure when he watches it, he will know that whatever the bailiff said was a lie.
No, I get that point. Now, I mean, the court had some not so nice words to describe the decision not to grant your application for an injunction. At worst, it said it was an abuse. It said it was an abuse of the
injunction application. When people were in court, we would have withdrawn the first one because the second one was supposed to substitute the first one. Clearly, because we were not in court, the court thought we had filed it twice. And so that is why it said it was duplicitous. That is basically it.
But you admit now that you were served, whether you were absent or not present at the time, and that the law firm was official.
The court says that the fact that he left it on the table constituted service.
Yes.
Of course, the court didn't have the benefit of maybe our CCTV coverage and things. Otherwise, maybe it should have, or if we were present, we would have. But if we were present, we were not, I was not aware because clearly I wasn't in the office yesterday. I had not received the process. So I wasn't aware that the case would have, because we need to formally be served. But the court says it constitutes service. You can't argue with the court over that point.
No.
Once the court has ruled, it has ruled. Well, so you move on.
No, I get that point. I wanted that clarity from you, that you're going to challenge anything related to that service process.
So what's the point? The motion has been held, has been heard and granted. And dismissed. What's the point?
Do you think that if we were to be present, anything would have changed in terms of this application?
Is that?
I'm asking whether.
Well, maybe.
I'm asking whether the court would have come to a different appreciation or ruling on the matter if you were in court.
Well, that would be trying to be futuristic. Nobody can tell.
No, I get your point. So now we are looking for the 9th of April where your next case is going to be heard, right?
Yes, exactly.
Anyway, I am grateful to you for your time this evening and for the clarity you brought to this conversation on this one. Many thanks to you, welcome, sir. Ni Papo Samuado is the lawyer for the Member of Parliament for South Dai, Roxanne Nelson Ndafiamekpo, whose case was early on today thrown out of court in the Supreme Court. Not the substantive case. I'm talking about the application for an injunction, which was thrown out. But this is important to some of us because it was this same application for an injunction that the Speaker said prevented him from actually going ahead and deciding on the matter that he was supposed, or allowing Parliament to consider Akufo-Addo's ministers and ministers designate that they are supposed to be passed by Parliament before they start the work. Is the reason why today you may not have a substantive information minister, because she's supposed to transition from deputy to substantive, and that has been caught in the wind. So that clarity is what really, and that's how important this case was, and this application for an injunction was. I'll be asking the experienced member of parliament, I'll be asking the former deputy attorney general whether parliament can now reconvene today or tomorrow, not tomorrow, I mean today is late, but tomorrow to now pass all of the people that he had vetted. And there's a report already ready for the plenary to consider. I think it's appropriate time to now introduce the Honorable Dr. Dominic Aine. Doc, you're welcome. It's been a long time. Nowadays, you're unavailable to engage the masses of this republic. This is what the people are worried about.
Oh, no, Raymond, I think that is grossly unfair. Oh. It's grossly unfair. I am engaging the masses in various, ways. And, of course, I'm a member of parliament, as you have said. I've been elected by the masses of Bolgatanga East, to work towards the enhancement of their welfare. And that's my primary responsibility.
Yeah, at large, serve the larger community, the Republic of Ghana.
And then, of course, serve parliament, as an institution of state.
And let me say very good evening to the wonderful residents of Bolgatanga East who are currently watching. I know always watch this particular platform. Now, let me now come to you. We know what is happening today. I would take your thoughts on it, but I want to go back because sometimes all of these applications and things confuse people about what's been happening.
Right.
Let's go to the point where Speaker Bagbin said, and of course, it was about the transmission of the Human Sexual Rights Bill to the presidency, and they did not want to take it. In fact, the detail indicate that they tried first or second time.
I think about 3 times.
3 times, and was rejected.
Right.
Then the Office of President officially wrote to Parliament, to that clerk, and said, don't you dare bring me this particular document because my hands are tied. There's a case in court. There's an application for an injunction related to this matter, and I cannot be seen receiving a document connected to it. That decision, we are told, was influenced by the learned Attorney General's opinion.
Yeah.
Is that a proper sequence of what has happened up to that period?
Yes, what you have said, fairly reflects what happened. All right, up to the point where Mr. Speaker took the decision that on account of the pendency of the case brought by the Honorable Roxinda Fiamakpo and the fact that there was pending before the court an application for interlocutory injunction, he was also unable, or Parliament for that matter, was unable to continue to conduct business, especially as it related to the approval of the ministerial nominees, because the case brought by Roxinda Fiamakpo touched and concerned the approval of ministerial nominees generally. And so on account of that, the Speaker also took the view that he did not want to do anything that would be seen to undercut the authority of the judiciary. And so that is why he adjourned Parliament sine die. But of course, subsequent events showed that the interlocutory interlocutory injunction application had not been filed at the time that the Speaker made reference to it. Factually, he made a mistake in referencing the injunction. But I think the larger point that Mr. Speaker made, and which was also probably the basis of the Attorney General's opinion to the President, which I disagree with anyway, was that the fact that a matter was pending before the judiciary, which is another co-equal, branch of government, the Parliament of Ghana was not going to act in a manner that would be seen to be a blatant disregard of the authority of the court. That is the same basis for Mr. President's decision not to even accept. It's not about assenting to the bill, not to even accept. A transmission of the bill from Parliament to the presidency. In large measure, the underlying rationale is the same, that you do not want to do anything that will undermine, the authority of the court. And so in the circumstances in which we found ourselves, I think that Mr. Speaker was right. Let me put it this way. In terms of the rationale given by Mr. President and that given by Mr. Speaker, right, I will say that they are not both on firm legal ground. All right, and that is why I say I disagree with the Attorney General's position on the matter.
But I cannot say that.
No, I'm coming.
Right. No, you say the President.
Let me. I want to clarify this.
I want us to restate it properly.
No, it's very important.
Yes.
I want to maybe I'm sounding contradictory, but I want to clarify this. I'm saying that both Mr. Speaker and the President gave as their rationale for doing what they did. In the case of the President, not receiving the transmission of the Family Values Bill, all right? And then in the case of Mr. Speaker, not proceeding to conduct the business of Parliament on account of the pendency of a matter in the Supreme Court, that the rationale for both of them was that they didn't want to do anything to undercut the administration of justice.
Yeah.
But now what I'm saying is that from a purely legal technical point of view, they were both wrong, all right? In the sense that nothing would, precluded either the President from accepting the bill, all right, despite the pendency of the matter, even though there was an interlocutory injunction application pending. Okay, that did not forbid or prohibit the President from receiving the bill. Okay, my reason is simple. And I think
you say that you differ in terms of school of thought and not that they were both wrong? Is it possible?
Yes, it's possible that they were both wrong.
Wrong, okay.
Yeah.
Yes, but I wanted to,
okay,
because
so
there are different schools of thought on this matter.
Look, there is, yes, the fact that there are, different schools of thought is fine. Two lawyers, on average, can differ on the same matter in terms of their conception of what is the true legal position, all right? But what I'm saying is that there is an intersubjective basis for saying that both of them were wrong.
Let's start with the President.
And yes, so
I want to remind you, based on the Attorney General's advice.
It doesn't matter. The Attorney General can be wrong.
Yeah, I agree perfectly.
All right?
Yes.
The Attorney General can be wrong because the Attorney General very well knows, okay, that it is tried law that you cannot place an injunction on the performance of a public duty, especially when it comes to the performance of a constitutional duty. All right? The President has a constitutional duty with respect to the granting of assent to bills for them to become law.
Yeah.
All right? And usually when, Parliament passes the bill, Parliament will transmit it to the Presidency. The President, if he decides to assent, will assent to the bill and send it back to the Clerk of Parliament for the necessary procedural steps to be taken.
Okay.
All right? For the bill, to be given a number at the Assembly Press and so on and so forth. And then it becomes law. It gets gazetted and becomes law. All right? So that's a constitutional duty. Okay? So for the Attorney General to say that the mere pendency of a matter and the fact that that matter also had an interlocutory, application that was, also pending, prohibited the President from even accepting the transmission of the said bill from Parliament. I think that the Attorney General misadvised the President of the Republic. So that is why I'm saying that, the Attorney General was wrong. Okay, as a matter of law, I don't see anything grossly wrong with the President accepting the bill and following through with the constitutional processes outlined in the Constitution itself. So, for instance...
But is that not the substantive element of whether or not the President can proceed to give an assent? That was being challenged in court.
Yes, that is what was exactly the matter in court. Okay, that the President should be prohibited from, granting his assent. All right. Basically, what you are saying is that the President should be restrained by an injunctive relief, okay, from the performance of his constitutional duty. Okay, and I say that is wrong. The court has made it, clear. The Supreme Court itself has made it clear that you cannot injunct or, restrain the performance of a public duty unless there are certain exceptional circumstances. All right. If it involves, loss of life, for instance, if it involves destruction, to property and so on and so forth, that is when the court can step in because some of the harm that will be caused will be irreversible. Okay. But in a situation where you are now saying that if the President signs the bill into law, okay, then that bill will offend that law will offend certain portions of the Constitution. Yeah. Okay. I think that first of all, it will be premature for you to say that the President should not sign it into law, all right? Because when you look at the Article 2 jurisdiction of the court, it is very clear that the issue of constitutionality, when it relates to a Parliament, okay, it relates to an enactment or anything done under an enactment, all right? So it is not just any act, because Parliament is a law-making body. Parliament doesn't take administrative decisions. Parliament does not take executive decisions, and so on. Parliament does not provide, make orders for people to act, or, forbid from, from acting in a certain way. Parliament passes laws, either in the form of, acts of Parliament, in the form of legislative instrument, that is regulations, or, in the form of, orders, like, the standing orders of Parliament. Okay, so in those circumstances, when you want to say that Parliament has acted unconstitutionally, you are challenging an enactment or anything done pursuant to an enactment after Parliament has passed it. So for you to now go to court and say something that is not an enactment, that is not yet law, offends the Constitution, okay, it is anticipatory, right? Because it doesn't yet have legal force for it to be offensive to the Constitution of the Republic.
In Richard Scott's
and then also
one of the issues he raised, Doc, is that there was also a quorum issue. I'm sure you've read that part.
Well, that is another matter, but I think the substantive, matter,
of course,
relates to the human rights issue.
How to offend the Constitution.
Yes. So you see, until the bill becomes law, it cannot alter rights or obligations or impose any liabilities.
And they cannot be arrested from doing so.
No, not at all.
So I suspect that your conduct or the bill you are putting in place is more likely to affect my human rights.
Yes.
I cannot stop it or seize it.
No, you cannot do so because there is a constitutional process that is yet to be completed. Mm-hmm. Wait for that to be completed. Because first of all, look, when the bill comes into force as law, all right, actions may be taken by persons such as the police to arrest someone who is engaging in an act forbidden by the law.
Oh, yeah.
All right. At that point in time, you can challenge the law as unconstitutional. Okay. Or when it comes into force, all right, and it is being implemented, by the agencies of state generally, then you can say that in the circumstances in which we find ourselves, the law itself or actions taken pursuant to the law are unconstitutional. All right. So I was going to say that, Raymond, when the president, said the bill, or the secretary to the president said Parliament should cease and desist. Mm-hmm. All right. Basically ordering Parliament. Mm-hmm. When there was a constitutional window of opportunity for the president to say to Parliament that I am refusing to assent to this bill for the following reasons, including but not limited to the fact that the matter there is a case in court.
Okay.
All right, that window of opportunity was there for the president to have transmitted the bill back to Parliament with a memorandum, however comprehensive, stating the reasons why he did not want, or he was refusing, to assent to the bill. The president didn't do that. So for me, I think that the president was, legally wrong. In the case of Mr. Speaker, okay, my reason is also simply that, you see, the mere pendency of that matter does not provide a basis for Parliament not to continue to conduct business, okay, because the long-standing principle of law has always been that, whatever happens in Parliament, as far back as the case of Tufo and the Attorney General, whatever happens in Parliament is a closed book. So Mr. President could have, on the basis, all right, of the principle enunciated in Tufo and the Attorney General, gone ahead, all right, to conduct the business of Parliament. That is approving the ministers. But of course, there is political wisdom in what Mr. Speaker did. And that is the point that I want to underscore this evening. The political wisdom in Mr. Speaker's decision was that he basically wanted to communicate to the executive branch of government that Parliament and the executive are two co-equal branches of government, all right? And they must, accord the necessary respect, okay, to the boundaries of authority, established under the Constitution. And so he was communicating a political message, and I think that it was done, so well. It might have been...
It was the wrong thing to do.
I don't know whether he knew.
Because in all fairness, the Speaker even said that he was reacting to an application for an injunction, which did not exist in the first place.
No, of course. So if Mr. Speaker gave a legal reason, which on hindsight is legally tenuous, all right, or even factually inaccurate,
Yeah.
all right, in and of itself, that doesn't, empty the action of Mr. Speaker, of any, what do you call it,
So what you're saying is that
in other words,
it's a means to an end, and that the means does not matter.
It matters. What I'm saying is that, okay, Mr. Speaker took a decision that is politically justifiable, in the sense that he basically wanted to communicate to the executive branch of government.
Is that what he's supposed to do?
Of course. Parliament is a political branch.
I get the point.
And the decisions we took, okay, the decisions we take on a regular basis are political decisions.
Okay, I get the point.
Yeah, so they may not be legally justifiable or legally accurate, okay, but the question will be whether they make political sense. And in this case, Mr. Speaker, he showed that, he had political wisdom.
Now, there is something that Justice I wrote some time ago.
Right.
He says that basically he was says the prevailing legal authorities tell us that the constitutionality of a bill, which is yet to become law, may not be challenged.
Yeah.
And he says, so in such cases, the Supreme Court has declined jurisdiction.
Right.
Usually on grounds that the case is not ripe for determination. He proceeded to say that there's a significant difference between a bill per se and a bill-related matter. Mm-hmm. And a controversy, and of course, he said a bill controversy entails the substance of a bill and the things that the principles in the bill intend to allow, command, or prohibit. Mm-hmm. But he distinguishes that from a bill-related matter or controversy. On the other hand, which he says includes a controversy which relates to the processes or procedures which a bill passes through before becoming law. He is of the opinion that the two are not the same.
They are not the same, yes.
And is it possible that Richard Sky's case, for example, which is challenging, say, quorum related and other factors raised, are bill-related matters and also bill in a substantive matters, which have been mixed together.
Right. So, Justice Sai is right on both counts. First of all, when he says the substantive content of a bill cannot be challenged. Okay, you cannot go to court to challenge the substantive content
of a bill. Yeah.
But if it is a bill-related matter, it relates to the procedures, for enactment. And if the Constitution provides, a certain, the basis for taking decision, and Parliament has not followed, that rule, or the Constitution provides a rule, for taking decision, and Parliament transgresses that rule. That is a bill-related matter.
Yes.
Okay, but you see, again, I have, a problem with the manner in which we've been proceeding in relation to this issue of quorum. Okay. Right, all the way from the Justice Abdullahi case. Now it is, because you see, the practices and procedures of Parliament are meant to ensure the effective and efficient passage of laws, and other legislative decisions of Parliament, all right, such as resolutions approving ministers or resolutions approving loans and so on and so forth, all right. And there is wisdom in the saying that whatever happens in Parliament is a closed book to the courts, okay. That is because, you see, most of the time, you don't have the requisite numbers for various reasons to be able to take a decision. Okay. All right. So in those circumstances, quorum is usually presumed. Okay. Until it is challenged on the floor.
Until somebody raises the point.
Somebody raises it. I don't think that it is healthy for our constitutional democracy for external persons to be the ones raising issues of quorum and others to stammer decisions being taken by Parliament. Because when you do that, the possibility is that and then if the courts uphold it on the basis that on the day a decision was taken, the numbers were not up to those required, for a decision to be taken, then it means that several actions of Parliament will always have to wait for all the members of Parliament required to be in the chamber, to be present and to take part in the decision before you can say that it has met the constitutional threshold.
Anything that's problematic?
It's problematic.
Even if the decision
No, I mean, look at it
look at
it the world over. Whether you are dealing with the United Kingdom,
Okay.
or you are dealing with, the Congress of the States of America, all right? There is no, what do you call it, issue of quorum until it is formally raised on the floor.
Okay.
All right? And if I were a judge, I would be looking for evidence, okay, of rebuttal, not from what Richard Sky or any plaintiff says, but from the proceedings of Parliament.
I see what happened on the floor of Parliament.
Yeah, what happens on the floor of Parliament? Whether an MP stood up and said, we don't have the requisite quorum,
Okay.
and yet Parliament refused and went ahead to take the decision. That is the evidence I'll be looking for. Because the road we are traveling down now is going to be problematic for Parliament in the future. Okay, so for instance, take the political season.
Yeah.
From June,
they're campaigning.
Yeah, everybody is going to be on the field. Most of us are going to be on the field campaigning. All right. If you insist on meeting that numerical threshold for decisions to be taken, then every decision will have to wait, for us to return before the decision is taken. And that can, basically, what will I say, slow down the business of government.
I get your point.
Yes.
The point I was trying to raise with that is that a bill-related matter that is justiciable, that can actually be taken to court for a determination of this sort, like Skies did?
I think it is a bill-related matter that is justiciable because the Constitution itself provides the threshold for decisions to be taken. But what I'm saying is that should not be for third parties to raise for the court to now say, because you didn't meet the constitutional threshold, right, go back and take that decision
I see.
again.
I get your point.
Because basically what will then happen is that when the court says, well, this decision of Parliament was null and void and of no effect because Parliament did not meet the constitutional threshold of a quorum when it took the decision. What means is that Mr. Speaker will now have to table the decision again. Nothing prevents Mr. Speaker from tabling the decision and saying that, okay, can we now have a quorum, all right, to take this decision? But Ray, I want to point out that our new standing orders are provided for decision day.
Okay.
All right, yes, for decision day. I believe Mr. Speaker took a cue from the Abdullahi case, the Justice Abdullahi and Attorney General case. And we provided for decision day, meaning that leadership will communicate the decisions to be taken on that day and then make sure that they mobilize the numbers to come, to come to Parliament to be able to take it. But I would have preferred the default position, which is what is prevailing now, which is that let us presume that we have a quorum
until it is challenged.
Until it is challenged formally in Parliament by itself. And then also the courts should be reluctant, okay, to take the say-so of a third party outside Parliament in order to nullify decisions of Parliament. We should honor and respect the principle of law that what happens in Parliament is a closed book. There's a lot of wisdom in that principle.
I get your point. Now, see, let's get to the issue that has brought all of us here. It is this Human Sexual Rights Bill.
Yes.
What is so special about it that because of that, there appears to be grandstanding in Parliament and grandstanding at the executive level too? Well,
I don't know what is what is so special about it. I mean, there have been other legislative enactments that are also equally important. I think that it touches and concerns a very sensitive issue, the question of, the regulation of morality, okay, because, what the bill seeks to do is to promote, as its title says, Ghanaian family values, and to prohibit certain actions that are contrary to or that are subversive of established Ghanaian family values. All right. So there is a lot of emotional reactions to whatever took place in Parliament, and then also whatever is happening with respect to
have been a very smooth passage. The passing of the bill, right?
Yes.
Bipartisan, by all standards.
Right.
I mean, all those there, I did not hear anybody say that he was opposed to the bill.
That is so.
So if Parliament agrees generally, and you say that you are representatives of your constituents in many of these forms, presumably your constituents also agreed to the bill and actually supported the way you actually carry it.
Yes, and I like the way you qualified it, presumably. Yes. because none of us actually conducted an empirical survey.
You didn't ask your people first
and we always presume that whatever we are doing is backed by on behalf of the people. So yes, I mean, you can say that presumably our constituents backed it. I mean, I did in my case, I did a kind of a straw poll, where I asked people in the constituency, including opinion leaders, what their thoughts were with respect to this. And to a person, they all told me they were for the family values bill, meaning that they are against, the promotion of gay and lesbian activities in the country. So for me, there was no question asked. I mean, I was convinced that the people of Bolga East, if we were to conduct a poll, would overwhelmingly vote for the family values bill. So I could not have been seen to be opposing it, given the fact that in the circumstances in which we all find ourselves.
But now they have raised issues about 3.8 billion, likely to be the amount of monies we may lose. In dollars, really. That's huge amount of money. Almost 4 billion that we may lose in the process. They have also raised questions about the external people, the people at UN and other places who may see us as a pariah state, and all the other issues that have come up. Is it possible that those of you in the minority will say, okay, let's just stand down this bill and everybody will be okay?
There's no price to pay for the maintenance of the values that we cherish as a society. There's no price. Not even 3.8 billion dollars should let us back down.
It's a country that just finished a domestic debt exchange.
Well,
program.
You see, we are there's a tendency for us to become too materialistic and then to throw away, the values that our people cherish, the cultural values that they cherish, so much. So for me, there's no price to pay for that.
Because people say if this bill is out of the way, there will be peace around the legislative process. And the presidency is not going to be engaged in similar grandstanding.
Yeah, and mind you, Ray, you see, sovereignty, the Constitution itself says, resides in the people of Ghana. Yeah. In whose name and for whose welfare, underline whose welfare, the powers of government, are exercised. All right. So for me, if the sovereign people of this country, all right, the sovereign parliament, as Mr. Speaker has said, has passed a law, all right, which in its wisdom seeks to promote, values, cherished by the good people of this country. I think that we should move ahead with them, with the law, despite the fact that we may be suffering financially, and in many material respects as a result of passing the passage of the law.
Today, in court, it was interesting. Of course, I was speaking to Nick Papo-Samuadu, who is a lawyer for, what they call it, the MP, Roxanne Nelson Dafiamepo. The case has been thrown out.
No, the case hasn't been thrown out.
I'm talking about the
injunction application has been thrown
out. Yes, the substantive case is there. I distinguished that earlier. Yes. But that injunction application has been thrown out.
Yes.
Abuse of court process is what was the target.
Well, an abuse of court process, as the lawyer explained, it was because I think they repeated the application, okay, and the court thought that was an abuse of court process. Basically, an abuse of court process is a situation where you either unreasonably or unjustifiably, uses the court, the court process, to advance your course of action. Okay, so the court, in its wisdom, thought it was an abuse of court process. That doesn't mean that the substantive matter will not be looked into. So I'm sure on the 9th of April, when they go back, they will advance their arguments in support of the substantive matter.
But the Attorney General says he's the one who asked for an expedited trial. It was out there that they are pushed it forward ahead of the Richard Sky case, which was filed 2 weeks ahead of this particular case. And that people felt it was a bit irregular. But the Attorney General said, well, I filed for it, and it was an option.
Okay, so I have listened to the Attorney General, and unfortunately, he's not giving a good impression of ethical conduct, as a lawyer.
So
I'm being very honest and upfront with you on this one. The reason is simply because if you want a court to give an expedited hearing, there is something we call an application for abridgment of time. You file that, you serve it on the other party, okay? And then they can prepare themselves and come to court on the abridged date, okay? You don't go Nicodemously to the registrar of the court or to the CJ, who is the chief administrator of the judiciary, to ask for the thing to be abridged. Then the registry puts the case, abridges time for you, all right, and then serves notice on the other parties to come to court immediately. That is unethical.
How?
It's grossly unethical. Okay, you are subverting the rules, of procedure in your favor, and that is all. It doesn't matter that you're the Attorney General of the Republic. You need to apply, for abridgment of time and serve notice on the lawyer on the other side, because the lawyer on the other side should not be taken by surprise. It is unethical for you to ambush another lawyer in the conduct of a case.
But in this case, it doesn't matter to serve them. The court says when you leave it at the firm.
That was not the hearing notice. For me, my understanding is that it was not the hearing notice for this particular matter. Was it? It was. What do you call it? I don't think it was was it a hearing notice?
That is what he said, that the court was serving the lawyer, Samuel Papus Ado's firm, with the hearing notice. But they were not there. So they said we left it there.
Okay. So was it the hearing notice, or it was the application for abridgment of time? So my point is not about the hearing notice.
Okay.
My point is about the abridgment of time. Whether the Attorney General applied for an abridgment of time, or he walked to the registry and say, issue a hearing notice, abridging time for an expedited hearing.
To those who do not understand these legal terms,
yes.
What's the difference anyway?
The difference is that in the case of an abridgment of time application, you file a formal application, all right, before the court.
Okay.
And that application seeks the court's, the exercise of the court's discretion, all right, to bring the hearing of the case forward because, of some exigencies that you will depose to in your affidavit in support of the application. And if the court agrees with you, all right, they will, abridge the time. They will shorten the time for the hearing.
Okay.
And usually the counsel on the other side will also have his client probably, depose to an affidavit in opposition. All right.
All right.
To your application. Right. But
so
the situation that we are faced with is a situation where the Attorney General literally walks to the registrar of the court and ensures that a hearing notice, abridging time, is served on the lawyer on the other side. That's what he's saying. That's what he.
Yeah, because what happened in court was the court service of a hearing notice.
Yeah.
There's no talk about abridgment of time.
So when was the application supposed to be heard? Ordinarily, when was it supposed to be heard?
What was I'm not sure.
No, you see, when you file an application for an injunction or any interim relief, usually on the motion paper,
they say like 8 days. They should.
No, not that. The registrar will indicate a date on which the application will be taken. All right. So my question is, when was it ordinarily fixed to be heard?
Okay.
I assume, I don't have the processes here, but I assume that the date fixed for that motion was not today. Okay? The reason why the Attorney General went to court and asked for a shorter period, a shorter date, or an expedited hearing, is because he could not wait for it to be heard on the date that it ordinarily would have been heard.
Okay.
All right.
Because their expectation was that there was an earlier application, that's the Richard Sky one, which was 2 weeks ahead of time, which had not been scheduled ahead of their case. So they wasn't expecting it to be scheduled anytime soon. That's what the lawyer was explaining.
Oh yes, I heard him. I heard him on the program. But the point I'm making is that where you want a case, heard expeditiously. You apply formally to the court, and you serve notice on the parties on the other side, to come to court, and you give reasons, justifiable reasons that the court, in the exercise of its judicial discretion, will accept.
Okay.
And then say that, okay, on the basis of what you have said, we are bringing the case forward for hearing. But that didn't happen in this case. And that is why I'm saying that the Attorney General, if he actually walked to the registry to ensure that the case was, heard expeditiously without a formal application to that effect, he was behaving unethically.
Now, that's an interesting point. I'm sure we can get him to clarify that, whether that's really...
I don't think you need to get him. He's had enough... I've been hearing him on air all the time, but what he does is that anywhere, are you in the office? You are a Deputy Attorney General. Is that not how people operate? No. I would never have done that. And my boss would never have allowed that to happen. The Honorable Maretta Brew would never have allowed that to happen. We would have applied formally to the court and would have impressed upon the court based upon the facts deposed to and evidence deposed to in our affidavit and judicial authorities to abridge time. We would never have walked to the court to secure an expedited hearing without a formal application.
He said he was even doing it when he was in opposition.
No. He was referring to abridgment of time.
Yes.
He could not have come from his private office to ask the registrar of the court to abridge time for him. No. He would have formally applied. He would have gone through the process.
But you suspect he didn't go through the process in this case?
Well, there was no application. He himself, when he spoke, he said that there was...
Samado said they had a search for it, but they couldn't find anything.
Yeah, there was no application. There was no application.
Well, that's an interesting development. But does it affect the substantive decision that was taken in court today?
No, I don't think so. The decision of the court today was based upon the merits of the application, and therefore, for me, I can't fault the decision.
Okay.
All right. But as far as the process is concerned, I don't think that the Attorney General did himself any good, and he did not do the judiciary of this country any good either. How? Because the impression was then given that the judiciary is bending over backwards, to ensure that the government's case. And remember that the Attorney General's case is the government's case. That the government's case is dealt with expeditiously. All right. And that is the case. The case.
And ministerial appointees.
Yeah, the ministerial appointees can be approved, expeditiously. But the government does not have, and we all know from the history of, the dealings between the executive branch and Parliament on the Family Values Bill. We all know that they are reluctant. The government is reluctant to have this bill, pass into law. And so, for Richard Cass's case, whether the injunction is heard today or it is heard in January 2025,
no, he said he's not interested in filing for an abridgment or anything close to that.
Well, that is where I see that he's being inconsistent. All right? Because on the one hand, you have the issue relating to the ministers, okay? And you want the court to hear it expeditiously. There is also an equally important matter that is pending, and that also affects the exercise of constitutional authority in this country by both the executive and legislative branches of government. For me, if I were in that office, or when we were in that office, we would have taken the matter seriously because it entails the exercise of constitutional authority for the benefit of the people of this country. As we speak now, the bill that has been passed by the people's representatives, as you pointed out, unanimously, without any objection, is hanging in abeyance.
Yeah.
Because the Attorney General has misadvised the President of the Republic, not to take any action because of the pendency of the Richard Sky matter. But then, because there is a constitutional duty on the part of the President to assent to the bill, the Attorney General should have been advising him that, Mr. President, the Constitution has outlined the processes necessary for the passage of this bill. If you have any objections to the passage of the bill, what I would advise is that please make those objections known to Parliament. And of course, in our time, the Attorney General would have been writing the President's objections, the memorandum to Parliament, for the attention of the President. If the President had any other reason, that will be added, and the Attorney General can then formalize it for the signature of the President for it to be transmitted to Parliament by His Excellency the President. So I think that what he did in staying the hand of the president, not only, in respect of whether he should sign the bill, okay, but also in relation to even accepting the bill for time to begin to run, okay? Is giving unconstitutional advice to the president of the republic. Really? He has advised the president to breach the constitution.
And that's a very tough word.
No. I am being very serious. He has misadvised the president to, undermine the constitutional authority, of Parliament.
Now, I'm asking you this question finally because how do we resolve this? Where do we go from here for there to be harmony between the executive and Parliament on this matter? Because it appears not to be ending anytime soon.
Well, the next line of action is for Parliament, right? When it concerns the the appointment, the approval of the minister.
So you have to call Parliament quickly before Easter and approve them.
Well, that is, unfortunately for the president, okay, that discretion is vested in Mr. Speaker.
Okay.
So Mr. Speaker can recall us, okay? But if Mr. Speaker is not recalling us, it can take, a petition of 1/3 of the members of Parliament, all right? That is about 90 members of Parliament sign a petition, seeking the recall of Parliament to consider, some urgent, business. Now, it is for them to, if they meet that threshold, okay, the clerk will recall Parliament. But guess what? The person who will make the decision whether the business should go on is Mr. Speaker.
Interesting.
Yes.
Do you get any inclination that you shall be recalled soon as Parliament?
Well, I spoke informally to members of my leadership, and yes, they said moves are being made for Parliament to be recalled.
Okay.
Okay, but probably not before the Easter break.
Okay. So were we expecting you to come? What time were you supposed to resume without this decision?
Would have returned to Parliament in May.
In May?
Yes.
But you're expected to come earlier so that
we're expected to come earlier so that we can take this one line, agenda item, and then dissolve again. But you see, that is where there is a problem.
Really?
The problem is that it is going to cost so much to bring members of Parliament back from their constituencies to reconvene in Parliament. Okay? And this is avoidable cost. If the presidency had done the right thing by simply writing back to Mr. Speaker regarding the family values bill, but now, okay, we would have been home and no one would have spent a penny having to convey members of Parliament back, to the floor of Parliament to take just one decision and go back to their constituencies.
You don't seem to support the recall.
Not that I don't. If I'm recalled,
it's an expensive venture.
It's a very expensive venture. And you see, what harm will be caused to this republic if we waited till May to approve the ministers? What harm?
The ministers are empty.
No, they are not empty.
There are caretaker ministers there.
No. You see, they are not empty. Let's be honest with ourselves. There are deputy ministers, all right? There are chief directors. The bureaucracy is working. And you can always appoint a supervising minister.
Which they have done, actually.
Okay? You can always appoint a supervising minister. You remember when the Honorable Dr. Kobna Donko was relieved of his post?
Yeah.
Okay? And the Honorable Abu Jinapo, was the deputy minister.
For a long time.
For a long time, it was the Honorable Setekpe, then finance minister, who was the supervising minister. And the power ministry didn't collapse.
Honorable, I thank you for your time this evening. We should do this consistent because there's an education part beyond your politics that you do to the people of this country.
I take this as a very serious exercise also.
Okay.
But of course, I have other engagements that sometimes do not permit me to be able to honor your invitation. But thank you very much.
And thank you for promising to come consistently. Ladies and gentlemen, that's where we end today's edition of UPFront. Many thanks to you for watching.